Welcome back to Title IX Coordinator Training. This is part 2 of the training. We are going to cover sexual harassment in greater detail today. We will talk about the scope and jurisdiction of the rule when it kicks in, what to do when you receive a report or complaint. We'll review the grounds for dismissal, and then we'll talk about the process timeline. And with that, we're going to dive right in. Another quick recap of what we're going to cover, but I just went over that, so we'll go ahead and move on. And we are going to start by digging a little bit deeper and taking a closer look at the definition of sexual harassment and the three different prongs. The first is quid pro quo, and that is when an employee conditions something of value in exchange for a sexual favor of some sort. The second prong is the Davis standard, and that's the standard that the department borrowed from the Supreme Court in the Davis case, and that is when unwelcome conduct is so severe, so pervasive, and so objectively offensive that it effectively denies the complainant access to the school's educational program or activity. And then third are the VAWA Clery crimes of sexual assault, stalking, dating, and domestic violence. So this is the definition of sexual harassment in 106.30 of the regs. And there are three prongs, as we've discussed. And these are three different categories of sexual harassment under the rule. And we are going to move right along to the first prong, which we also refer to sometimes as quid pro quo. And this applies when an employee of the school conditions the provision of an aid, benefit, or service of the school on an individual's participation in unwelcome sexual conduct. So let's talk a little more about this prong. This is the only prong of the definition that applies solely to an employee respondent. So if you have a report or a complaint that involves only students, you would never have a quid pro quo case because it applies only to employee respondents. You could obviously have a complainant that is a student. And this type of sexual harassment involves an abuse of authority by an employee. And unlike the second prong of the Davis or the second prong of the sexual harassment definition, or the Davis prong, it doesn't require a showing of severity, pervasiveness, or offensiveness. So if you have any employee using their position or their authority to, essentially manipulate, unwelcome or non-consensual sexual conduct from another person, it would be considered per se sexual harassment. So it requires only one incident, only one occurrence. It doesn't have to be, pervasive. And as most of you, I'm sure, appreciate as Title IX coordinators, in real life, these cases are frequently nuanced and murky. And in the case of quid pro quo specifically, it's not likely that you're going to have a case where a respondent just bluntly comes out and says, if you go on a date with me, I will give you an A in my course. These cases frequently involve faculty or instructors. Not always, but sometimes. So the department makes it clear that this type of harassment, quid pro quo, doesn't have to be explicit like that. It doesn't have to be so straightforward. It could be implied, by the conduct and behavior of the respondent and the parties. So the Davis prong, again, was borrowed from the Supreme Court. And it is defined as unwelcome conduct determined by a reasonable person to be so severe, so pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. And harassment under this prong is directed specifically at verbal or expressive conduct primarily. Because it involves speech, the department, was concerned about protecting freedom of speech and protecting academic freedom. And so they reasoned that this prong required an increased level of seriousness so as not to chill freedom of speech. And because they had the other two prongs, they felt that this category of sexual harassment in particular did require, a level of increased severity. So in terms of evaluating whether the conduct is severe, objectively offensive, and so forth, this prong is evaluated under the reasonable person standard. And it's the reasonable person standard taking into consideration the characteristics of the alleged victim or the complainant. So would a reasonable person in the shoes of the complainant find the conduct severe, pervasive, and objectively offensive? So although you are applying an objective standard, you'd be looking at it through the lens of that person, a person in those shoes. So you'd be considering their age, position, gender, their relative position to the respondent, etc. And of course, this is, objectively offensive conduct. So, and it is, relatively stringent requirement with the severe, pervasive elements. So obviously not every subjective, unwelcome conduct, where people may feel offended or, so forth, will not be covered. So the third prong is comprised of the VAWA crimes of sexual assault, dating violence, domestic violence, and stalking. Again, unlike the Davis prong that we just discussed, which must be so severe, pervasive, and objectively offensive that it denies a person equal access, incidents or allegations that involve any of these crimes don't have to meet those additional elements. And in addition to that, an allegation that involves any of these crimes doesn't have to cause complainant to lose equal access. An allegation implicating any of these is a de facto per se considered sexual harassment under the law. And if you have a case that involves any of these, then you are obligated to respond with really no further analysis other than the jurisdictional scope parameters that we'll discuss later. So I'm including the definitions of each of these offenses for your reference. I'm not going to read through each of them in detail. You can come back to them and refer to them. And you probably already have these in your policy anyway. But what's important to remember about all of these crimes that fall under this prong is, again, that they're considered per se harassment. So we're not looking at severity or pervasiveness. The sexual assault definition, it specifically includes all of the sex offenses listed by the FBI's Uniform Crime Reporting System. And all of these are going to involve some sort of physical violence and or sexual touching or contact without consent. And in the case of stalking, the threat or the reasonable fear of physical harm. So sexual assault is defined as an offense that's classified as a forcible or non-forcible sex offense under the Uniform Crime Reporting System of the FBI, which goes through and lists several other types of crimes. And those include any sexual act directed against another person without their consent, rape, sodomy, sexual assault with an object, fondling, incest, and statutory rape. So as we reviewed in the first part of this training, the rules themselves do not provide a definition for consent. And it's up to the school to determine how they want to define it, which definition they will adopt. And obviously consent becomes an issue when we're dealing with cases involving sexual assault, because sexual assault by definition involves non-consensual sexual contact. So presumably you've all already adopted a definition of consent because it's required under existing law, and you may have been required to utilize a state mandated definition. But this is an opportunity to revisit that definition if you think that it makes sense for your institution. And just keep in mind that for your current definition, or if you change a definition, it has to be clearly defined and consistently applied across all Title IX cases. And particularly in the context of utilizing an affirmative consent standard, you have to remember that it's the school's burden to collect evidence in reaching a determination, not the parties. And frequently in these close calls, when you're using an affirmative consent definition, it's easy to shift or inadvertently shift that a burden onto one of the parties, onto the respondent to prove that consent existed, or to shift the burden to a complainant to prove the absence of consent. So just make sure that you understand and appreciate that it's the school's obligation to collect evidence, not the parties. So the next three VAWA crimes, dating and domestic violence and stalking, are defined here exactly as they are in Clery, and I've included the definitions, which you see. And so, of course, these will be included in your Title IX policy. Not going to go over these in detail. The definitions are self-explanatory, and if Clery applies to you, which it probably does for most of you, you would be evaluating these just as you would any of the crimes that have been reported under Clery. So we've got dating violence, domestic violence. So that was domestic violence and dating violence. And then, of course, stalking is the fourth crime covered under the Clery VAWA prong of the definition of sexual harassment. And just a quick note about the overlap between Clery and Title IX. So obviously these definitions are taken directly from Clery and VAWA. And there is some overlap between Clery and Title IX. And you could be concerned about the potential of conflicts between your application of Title IX and Clery. The department discusses this in the preamble, and they note that there's obviously some overlap, and there are similarities, and there are some requirements that are the same. There are also requirements that are different, but there's no actual conflict between the two laws. So if you're subject to both Clery and Title IX, you should simply, follow the steps that you need to for Clery when you have one of these crimes that we've just reviewed. And then similarly, you will go through the other requirements or the different requirements, the checklist that you need to go through in ensuring compliance with Title IX. So you'll walk through both. There may be overlaps, there may be differences, but they shouldn't conflict with each other. Before we move from the definition of conduct that triggers Title IX, or what falls within its scope, I just want to be sure that I mention that retaliation is also prohibited under the rule. So in addition to conduct that fits the definition of sexual harassment that we just reviewed, conduct that's retaliatory in nature is also prohibited and requires the school to take appropriate action to address. So you wouldn't apply the formal grievance process if you have a complaint or allegation of retaliation, but under section 106.8 of the regs, you would implement a prompt and equitable process. So you've got a little more latitude there when it comes to retaliation. And the prohibition on retaliation states that no recipient or other person may intimidate, threaten, coerce, or discriminate against any individual for the purpose of interfering with any right or privilege under Title IX, or because the individual has made a report or complaint, testified, assisted, or participated or refused to participate in any manner. So retaliation could apply to more individuals than just the respondent and complainant in the case. It could apply, obviously, to witnesses or anybody that's involved in the process, really. So we talked about the definition of sexual harassment quite a bit through part 1 and part 2 just now of the training. And in addition to the alleged behavior that meets those definitional requirements, the rules also establish other parameters or other requirements that must be met in order for the Title IX rule to apply. And I'm referring to these as jurisdiction, scope, and standing. And they can also be thought of as the who, what, why, when, where details that establish whether the incident or allegations fall under Title IX or whether they would be handled under the school's other conduct policies if applicable. So the who, any person can make a report, but only a complainant can submit a formal complaint or the Title IX coordinator. But a complainant must be actively attempting to participate in the school's educational program or activity. It doesn't necessarily mean that they have to be currently enrolled, but they do have to be attempting to participate. So they could be on some sort of leave. They could even be a graduate that is trying to or wants to avail themselves of some opportunity, alumni opportunities and so forth with the school. And the respondent must be enrolled or an employee or otherwise under the recipient's or the school's substantial control. The what is the conduct that falls within the definition of sexual harassment, one of those three prongs. Quid pro quo, the Davis Standard, or the Cleary-Vawa crimes. The why is the whole thrust of the Title IX law in the first place, to prohibit discrimination on the basis of sex. And then when. Considerations around the when. There is no statute of limitations that applies to Title IX matters. So there's no time limits on when someone can submit a report or a complaint, assuming all of those other conditions are met. But it obviously has to have occurred within the school's educational program or activities. And then, of course, although there's technically no limit on when someone could file a report or complaint, you have to consider the school's ability to gather sufficient evidence to carry that burden of proof. And we'll talk about that when we discuss the dismissal provisions of the rule. And then the where, under the rule, the allegations must have occurred in the United States and within the school's educational program or activity. So the educational program or activity is defined as locations, events, or circumstances where the school exercises substantial control over both the respondent and the context in which the alleged sexual harassment or discrimination occurs. Notice it says context, not location. And this would include any building owned or controlled by the school or by a student organization that's recognized, officially recognized by the school. It could also apply to online activities, email, even old-fashioned snail mail or other communications. So it's not limited to location, and it can occur in a more intangible way through online activities. And then again, the rule isn't limited to conduct occurring solely on campus. So just to recap, these are the elements that must be met for the allegations in a formal complaint to trigger a Title IX response. First, the school has to have actual knowledge. And as we talked about in part 1, this is when the Title IX coordinator or an official with authority receives notice via a report or a complaint of allegations that could constitute sexual harassment. And then the parties have to have standing, and that's my term, but it's a shorthand way that helps me kind of categorize all of this. And the complainant as a party has to be attempting or has to be enrolled or attempting to participate in the school's educational program or activity. And then, of course, the respondent also must be enrolled or an employee or otherwise be within the school's control. With respect to the jurisdiction and scope, The conduct must have occurred in the United States and again within the school's educational program or activity. And then lastly, of course, it must also fall within the definition of sexual harassment under these rules. So formal complaint is defined as a document filed by complainant or signed by the Title IX coordinator alleging sexual harassment against a respondent and requesting recipient investigate the allegation of sexual harassment. So what does that mean exactly, and what does a formal complaint look like? The department says that the definition for a formal complaint describes the purpose of the complaint, not the requirements for the specific language or format. And they specifically discuss in the preamble that schools should not take the requirements of a written formal complaint to create a bureaucratic loophole, in their words, or other technicalities to avoid initiating the grievance process. So in other words, if a formal complaint is missing information or a signature, but it's obvious that somebody was trying to submit a formal complaint, the school should still contact the complainant, help them in correcting, the missing or incorrect items on the written complaint, and then move forward through the process as required. So the point here is that you're not looking for mistakes or requiring, very specific technical requirements, be met. The purpose is that you have a process that's clearly understood to be starting the formal investigation and the formal grievance process. It's not to nitpick the formal or specific items on the form. And although there's no verbatim requirements for the language to be used, I would recommend that schools create a formal complaint form that includes fields to collect important and required information. And also, don't forget about the record-keeping requirements and that schools are required to document how and why their responses at almost every stage of a Title IX matter are not deliberately indifferent. And the department states that this is an additional safeguard against a school intentionally treating imperfect paperwork as a grounds for refusing to take action upon receipt of a document that purports to be a formal complaint. So how does one file a formal complaint? According to the preamble, again, the goal is to make the filing of a complaint as accessible as possible. And the regs are specific in stating that a complaint may be filed with the Title IX coordinator, either in person, by mail, or by electronic mail, using the contact information that was listed for the coordinator. In addition, schools may identify any additional method that they would receive a formal complaint, for example, an online portal. But a formal complaint can't be filed by phone because it has to be in writing. So that's important to remember. And it also couldn't be filed verbally unless the complainant was meeting with the Title IX coordinator and they were completing the formal complaint in writing together. So note that the rules don't restrict the method in which a report may be received. So a report is different from a complaint. So a report could be taken in by any means of communicating with the Title IX coordinator or an official with authority. So a report could be made by phone and it could be made, verbally. And lastly, to recap, schools must disclose the contact information for the Title IX coordinator on their website, in their catalog, and any handbook that they use. And the information that they publish on their website must be published prominently. So only the Title IX coordinator may initiate a complaint if the complainant doesn't want to. And the preamble talks about the fact that Title IX coordinators are trained and experienced in Title IX and in dealing with these cases and complainants. And so, they have special responsibilities, obviously, under Title IX, and they are best positioned to make this judgment call. So other officials at your organization can't initiate a formal complaint. That is the job only of the Title IX coordinator. So obviously, as a coordinator, you would do that if you believe that the allegations warrant a formal grievance process. And you're making a decision in that case to move forward on behalf of the school, not necessarily on behalf of the complainant, because it's the school that has an obligation to uphold and comply with Title IX. And of course, the school has an obligation not to act with deliberate indifference. So also remember that if the allegations would warrant disciplinary action, the school can't institute punitive or disciplinary action or sanctions without first going through the grievance process. So if you have a situation where the complainant doesn't want to move forward, but the incident or the allegation is serious enough, and that would require some sort of disciplinary action, you would have to go through the formal process by the Title IX coordinator, signing and initiating that process before implementing any punitive or disciplinary actions. So let's talk about what happens if someone submits a report or a complaint anonymously. How would you handle these situations? And are they allowed? The department touched on this in the preamble discussion, and they stated that the regulations do not prohibit schools from implementing anonymous or blind reporting options. So if a school allows or otherwise permits anonymous reporting, remember that the school has actual knowledge when such a report goes to the Title IX coordinator or an official with authority. And when it happens, obviously the school is under an obligation to respond in a manner that isn't deliberately indifferent. So also recall that anyone may report sexual harassment. So a person could submit a report anonymously, not revealing their identity, but identifying the identity of the alleged victim or the complainant. So in this case, the school's mandatory response obligation kicks in, even though the report itself was submitted by an anonymous individual. And under that obligatory response requirement, the school would have to meet with the complainant, contact the complainant, meet with the complainant, and offer supportive measures. Now, if a report came in and the complainant's identity was not provided or disclosed, then the school obviously couldn't contact the complainant to offer supportive measures. And of course, in that case, they wouldn't be in receipt of a formal complaint because that requires the complainant to sign or otherwise confirm their identity. So all of that said, the Title IX coordinator may sign and initiate a formal complaint. And although the complainant's identity typically does need to be known, both to investigate the case and importantly, to provide sufficient notice to the respondent so that they can respond appropriately and have their due process rights protected. If the coordinator determines that the allegations are serious enough, they might initiate a formal complaint and begin an investigation, even if the complainant's identity is unknown. So what do you do when you receive a report or a formal complaint? This is a quick snapshot of all of the steps that you would take as a Title IX coordinator. As I'm sure you will appreciate as you take a look at these steps, they may overlap and they may not always unfold, in this exact sequential fashion, one at a time. But these are all of the things that are going to happen when you receive that initial report or complaint. And of course, the very first step that you're going to take upon notice, either of a complaint or by way of a formal, either through a report or by way of a formal complaint, is to actually meet with the complainant. And you will meet with the complainant, and this entire process is essentially an initial assessment of the case and of the matter. And through the various steps in this process, you'll be conducting that initial assessment, which, depending on the circumstances, could involve a threat assessment, which we're going to talk about in a minute. But you'll meet with the complainant, and of course, the first thing you're going to do is discuss supportive measures. you have to get input from the complainant. That has to be an interactive discussion. You need to understand what is going to work for them, what they want to do. And using that information, you would determine which supportive measures are reasonable under the circumstances, and you would move forward with implementing those. You would also discuss and describe the complainant's various options in terms of how they might proceed. If they filed a report, then you would obviously describe the option and process for filing a formal complaint. And you would let them know, obviously, that they have a right to supportive measures whether or not they do move forward with a formal complaint. After all of that has been accomplished, if they decide not to initiate a formal complaint, you would respect those wishes unless not moving forward with a formal complaint would mean that your actions were deliberately indifferent, under that standard that we talked about in the first part of this training. And you might choose or decide that you need to initiate a complaint without the complainants wanting to. So if a formal complaint is made, you would begin the grievance process. You would, assemble your team, you would assign an investigator, and most importantly, before anything, you would send a notice of allegations to the respondent, which we're going to talk about in detail in the last session when we really get into the meat of the grievance process. And then, of course, you want to document everything and every action and every decision, and provide the basis and the rationale for why those decisions weren't deliberately indifferent. So as I mentioned, when you receive a report or complaint, that whole process involves you making an initial assessment of the situation as the Title IX coordinator. And as part of that assessment, you may determine that the respondent poses a threat or a risk. And there is a process under the regs to remove a respondent from campus under these emergency removal provisions of Section 106.44. So this is a limited exception, and it's the only real limited exception to the prohibition on implementing, punitive measures before the formal grievance process has been conducted. So an emergency removal may be implemented if, after conducting an individualized risk and safety assessment, the school determines that the respondent poses a threat to the physical health or safety of any student or any other individual arising from the allegations of sexual harassment in the complaint. The intent of this provision is pretty clear, but it's to allow schools to take appropriate measures to protect members of the campus community when there is a genuine emergency. In order to determine if there is an emergency, if there is such a threat, without providing that prior notice and opportunity that is, so important as the department is trying to protect those, due process and fundamental fairness rights, the school does have to allow a challenge, but they don't have to allow it prior to taking the emergency removal action. And so they need to allow an opportunity for the respondent to challenge the decision, and then they need to do so immediately after the removal. As with every other action under these rules, the school, of course, must document the removal with appropriate justification for the decision. And this provision, the emergency removal process, applies both to students and employees. And there is one more specific mention in the regulations in Section 106.44D that authorizes schools to basically put employee respondents on administrative leave. And under those circumstances, the schools have discretion and the authority to do that. even if these emergency removal conditions don't apply or are not met. They're two completely different things. So if a report or a complaint has been filed, as part of the intake process, you're going to be assessing that matter, that complaint. And you've met with the complainant, you've offered and implemented supportive measures, you've conducted a threat assessment that might necessitate or justify an emergency removal if that's applicable, as we just discussed. But as part of this assessment and part of this intake process, you're going to obviously need to analyze the case to determine if it's covered under Title IX. Does it fall under Title IX? So we talked about actual knowledge as a condition of these rules kicking in the first part of this training. And as we talked about, the school has actual knowledge if a report or complaint goes to the Title IX coordinator, or if a report or complaint goes to an official with authority to institute corrective measures. So if those two conditions are met, obviously you have actual knowledge, which you would if you got a report as the Title IX coordinator, and then you would analyze, the jurisdiction and scope of the case. So does the matter cover the parties? Is the complainant actively engaging or attempting to engage in the school's program or activity, educational program or activity? Does the school have significant control over the respondent? Are they enrolled or are they an employee? Did the conduct happen in the United States? And of course, did the conduct occur or the allegations occur within the scope of the school's educational program or activity? So if all of those are true, you would need to assess, is it sexual harassment under Title IX? And of course, you would apply, the definition of sexual harassment as we've reviewed the 3 different prongs. Is it a quid pro quo type of harassment, or is it a clear crime? Sexual assault, stalking, dating, domestic violence. If so, you only need, again, one incident of those types of conduct from occurring, and per se, it falls within the scope of sexual harassment definition. And then, of course, the other prong is the severe, pervasive, and objectively offensive. So if you have actual knowledge, it falls within your jurisdiction and scope, and it meets the definition of sexual harassment, then you would move forward with the formal grievance process as appropriate if you have a formal complaint, and it falls within the scope of Title IX. So if you go through that analysis and the allegation does not trigger a Title IX response, again, you have to implement supportive measures. A very important part of this process. And then you would, more likely than not, refer the matter to your non-Title IX misconduct processes. So that's something to think about as you are thinking about adjusting, revising, updating your policies and procedures to comply with these new rules. You might want to take a look at your other non-Title IX misconduct policies and procedures, because you may be managing a higher number or higher volume of sexual misconduct cases that do not fall under the Title IX definition, scope, requirements. So just give that some thought. And this is another way, this is a simplistic graphic here, but another way to think about the applicability of Title IX as you're analyzing whether it applies or not. So if you think about this target as all of the conduct or misconduct that's prohibited on your campus and under your policies, the innermost circle, the red circle or the bullseye, represents misconduct that also meets those definitional and jurisdictional and scope requirements of Title IX. But that doesn't mean that if you have an incident of misconduct that doesn't fall within the definition of sexual harassment or didn't occur in the US, or some other factor that brings it outside of the scope of Title IX, that doesn't mean that you would necessarily ignore it. You would address it under your, non-Title IX conduct, code of conduct. So it would still be addressed, and that's just important to keep in mind, that you aren't just walking away from cases that involve, other types of sexual misconduct that don't fall within the scope of Title IX. So we covered supportive measures in part 1 of the training, but it's such an important part of your mandatory response obligation and part of how you're going to respond to each and every report or complaint of sexual harassment. I just want to mention it again. And I don't think I did this in the first part of the training, so I wanted to just include a list of some common types of supportive measures. This isn't exhaustive. These are just some of the common supportive measures that one finds across different schools. A type of supportive measure would be referring the complainant to counseling or medical or health services, referring an employee to an employee assistance program if you have one, implementing a mutual no contact order. And under these regulations, it's important to remember that any do not contact or no contact order has to be mutual. It has to apply equally to both of the parties. Supportive measures could include financial aid counseling, making changes to the complainant's housing situation if you have on-campus housing, for example, or altering their work or class schedules, safety planning with the complainant, providing escorts, campus escorts, for example, providing academic accommodations, more time, and so forth, and these other items that are listed here. So let's move on to dismissals, which are covered under section 106.45. And there are 4 bases for dismissing a formal complaint, and one of them is mandatory. The other 3 are discretionary and will depend on the circumstances of the situation and require a judgment call by the school, depending on those circumstances. So a formal complaint must be dismissed if it doesn't meet the definition and jurisdictional requirements that we've just gone over. So that is mandatory. Again, it can be handled under your non-Title IX code of conduct, but it would not be a Title IX matter. The last 3 here are the discretionary basis for dismissal. The school could dismiss if the complainant wants to withdraw the complaint. And more likely than not, unless the Title IX coordinator feels that they should proceed and that they would sign a complaint on behalf of the school, it's important that you respect the wishes of the complainant not to, want to go through that formal process. Something to keep in mind. You could also dismiss if the respondent isn't enrolled or employed with the school. And then lastly, you could dismiss if there are specific circumstances that prevent you from gathering sufficient evidence to reach a determination in the matter. So if the conduct alleged in the formal complaint meets any of those elements, any of these elements here, it must be dismissed. So this is what the law says exactly, section 106.45B3. If the conduct would not constitute sexual harassment as defined in section 106.30, even if it was proved, if it didn't occur in the recipient's educational program or activity, or it didn't occur in the U.S., if any of those conditions are met, then the school must dismiss the formal complaint for purposes of Title IX. And these are the discretionary dismissal grounds. If the complainant notifies the coordinator in writing that they would like to withdraw the complaint or withdraw any allegation, and that applies across all of these dismissals. A dismissal may apply to a single or multiple allegations within a complaint in addition to the entire complaint. If the respondent is no longer enrolled or employed by the school. And lastly, if there are specific circumstances that prevent the school from gathering evidence sufficient to reach a determination as to the formal complaint. And this might occur, for example, if the complainant chooses not to participate in the process and the school is unable to gather, evidence without the complainant's cooperation. A couple final notes about dismissals. I believe I just mentioned this, but they apply to individual allegations or the entire complaint. And the school must provide written notification to the parties of any dismissal, including the reasons for the dismissal. And lastly, mandatory dismissals are appealable. Okay, moving on to a new topic, which is informal resolution. So under these rules, a school may offer informal resolution as an alternative to the formal grievance process. Some examples of informal resolution are mediation or restorative justice. But these should only be offered as an option if the Title IX coordinator determines they're appropriate to the situation. Informal resolution may not be appropriate in every situation, and that is a judgment call for you as a Title IX coordinator. But obviously keep in mind that these are options, but they may only be offered as an option if you do allow them after a formal complaint has been filed. And the informal resolution process could happen at any point of the grievance process after the grievance process has been initiated, as long as both parties willingly and voluntarily consent in writing to attempting informal resolution. Also, very important, either party can withdraw from that informal process at any time, and the school would need to reinstitute the formal grievance process. Just as with all of the other Title IX personnel and roles, anybody that facilitates informal resolution has to be trained, and they have to be trained on all of the topics that we covered in part one of the training. And this is important. Informal resolution can't be offered if the allegations involve an employee sexually harassing a student. So if you have an employee respondent, then you can't use informal resolution. And if the school does use the informal process, they're required to provide written notice disclosing the allegations, the requirements of the process, including the circumstances that would preclude the parties from resuming a formal complaint, such as you go through the entire formal resolution process. Obviously all of the conditions are met regarding, it's a voluntary process and so forth, and you reach a final determination, to which both parties at that point would agree because they could withdraw at any point. That determination could be final, and that needs to be disclosed clearly to the parties. And then, of course, you also need to include in that notice any of the consequences that could result from the process, including what records might be maintained or what records might be disclosed or shared if the parties were to undertake that process and potentially revert back to the formal process, for example. Let's shift gears and talk about timeframes for these processes and the Title IX formal grievance process. So you must include reasonably prompt timeframes for concluding the process. And importantly, these timeframes are inclusive of the entire process, including appeals and informal resolution, if you choose to offer informal resolution or the parties opt for it. Schools can allow delays and extensions as long as they are temporary and reasonable, and they're permitted only for good cause. So under prior guidance, you may recall that the department had set forth a 60-day time frame that it strongly recommended for resolution of Title IX cases. And under these rules, you have the option of coming up with a reasonably prompt time frame that works for your school. So you certainly could choose to utilize that 60-day time frame if you thought it's reasonable, if you think it's reasonable, and you think it allows for prompt, resolution of the matter of these cases. But importantly, you have to ensure that you've adhered to all of the procedural requirements and protections that are necessary under the rule. That's all of those requirements under the grievance process in particular. So the schools may designate a longer or different time frame, again, as long as it leads to a fair resolution. And keep in mind that under these rules, there are fairly stringent procedural protections in place, and those include providing sufficient notice, in advance of every meeting, every interview. And then, of course, a school has to provide, and we'll talk about this in the grievance process in the third part of the training, but the school has to provide a 10-day time frame for the parties to inspect and comment on evidence prior to finalizing the investigative report. And then they have to offer another 10-day time frame for the parties to review the investigative report and respond in advance of the hearing. So depending on what your process looked like before these rules, it could be longer than 60 days based on these additional procedural and notice requirements. That said, as long as your process is reasonably prompt and complies with those procedural protections, it's up to you to determine how long it will take. So we understand the process must be reasonably prompt, and we are all probably able to estimate, what that time frame would typically look like if we had full control of the situation. Although none of us have yet had to adhere to these requirements, so maybe that's not completely realistic. But even if you could estimate, what the time frame is going to look like in your typical case, obviously all of these cases are different. Life is messy and unpredictable, and these cases, are frequently complicated with lots of different variables to account for. So let's talk about some of those variables and the types of delays that you should think about in advance when you are updating your policies and determining what your timeframes are going to look like. So to recap, delays and extensions are permissible if they are temporary, limited, and justified. If you do encounter a delay or need to provide an extension, you must provide written notice to the parties, and this notice must include the reason for the delay. So the department makes it clear that this provision doesn't allow for open-ended or indefinite processes. This seems pretty obvious. And you'll have to publish your own time frame, so you are going to be accountable to publish time frames that you've established in your policy. And the department also makes it clear that delays that are caused solely by the administrative needs of the schools aren't sufficient basis for delay. And they discuss specifically in the preamble that a school's inefficiency or mismanagement of their own resources isn't an acceptable reason for delay. The rule does specifically mention that the absence of a party, witness, or advisor may constitute good cause, as well as a concurrent law enforcement activity, or the need for language assistance or accommodations for disabilities. They also note that the time frame under this rule aligns with the Clery Act, which also requires prompt resolution of processes to address harassment and those sex offenses that overlap with Title IX. Okay, so I want to touch on the issues of concurrent law enforcement activity and the availability of participants in the process. They obviously relate to the time frame in these matters. So let's talk first about concurrent law enforcement activity. The Title IX process and the criminal process are obviously two distinct, separate, and independent processes. And as a school that receives federal financial assistance, you're obligated to respond to Title IX sexual discrimination and harassment allegations, irrespective of any potential criminal matter. So you can't delegate, responsibility for your Title IX determinations to the criminal process. Title IX and the criminal laws serve different purposes, and although these processes can sometimes overlap, and law enforcement, a law enforcement investigation could justify a delay or extension. For example, if a criminal investigation has uncovered evidence that may be material to your Title IX investigation, then a temporary delay to gain access to that evidence, would constitute good cause for a delay, as long as that delay is not protracted or open-ended. You can't, as a matter, of course, simply delay the Title IX process and then wait for the conclusion of a criminal matter. You still have an obligation under Title IX to promptly resolve and apply your school's grievance process, even if a law enforcement matter is ongoing. So moving on to delays or extensions caused by the unavailability of parties or others that are involved in the process. So this shouldn't be a draconian process, and clearly you would allow, reasonable short delays due to illness and so forth. But how do you handle a non-cooperative party or witness? Under the rules, a party or witness cannot indefinitely delay the grievance process by refusing to cooperate. So you have to move forward whether or not the parties or others, want to cooperate with you and participate. You obviously would try to accommodate, individual schedules in order to allow them to meaningfully participate. And you are obligated to, conduct and conclude the process as, reasonably promptly as possible. But under the regulations, the process can proceed even in the absence of a party or witness. And so also keep in mind that parties may participate remotely, which provides flexibility in terms of the time frame. And if you do have a party that chooses not to participate, keep in mind that you are required to keep that party informed, and you are still required to provide them with all of the notices and communications that you would otherwise be required to, irrespective of their participation in the matter. So that is it for part 2. Let's do a quick recap of what we just covered. Obviously, we looked at the definition of sexual harassment again in a little more detail. There are 3 types or prongs that trigger of sexual harassment that trigger a school's response. And in addition to that definition being met, the conduct must have occurred in the scope of the school's educational program or activity. Again, that's not limited to on-campus activities. And it must have occurred in the U.S., and both the respondent and complainant must be, enrolled or otherwise engaged or under the school's control. And once triggered, the school must respond whether or not a formal complaint is filed, and they must respond with supportive measures that ensure complainants have, continued access to the educational program or activity. And the coordinator will need to conduct an initial assessment of the case in order to, determine next steps. If the case doesn't fall within the scope of Title IX, it must be dismissed, but it may be handled under the school's other policies. Schools have the option of utilizing informal resolution, but they may do so only after a formal complaint has been filed. And of course, the parties must voluntarily agree in writing to attempt informal resolution. And then last but not least, the entire process must be resolved within reasonably prompt timeframes. So that's part 2, and part 3 will be the final session of the training. We're going to drill down into the procedural protections that are embodied in the grievance process. So we will be talking about the investigation, the hearing, which includes cross-examination and appeals. So with that, thank you so much for your attention, and I look forward to concluding the Title IX coordinator training in part 3.